Good afternoon, sir. Could I have your name, please?
Jonathan James Winter.
All right, Mr. Winter, my name is Judge Hesslink. I'll be arraigning you this afternoon. That involves me reading the charges to you, then telling you what your rights are, and then addressing bond. I have with me on Zoom Mr. Brown as a defense attorney and Mr. Fortier from the prosecutor's office. The charge in the complaint against you reads as follows. It says, in honor about July the 10th of 2025 in Bagley Township of Otsego County, that you did commit the following two offenses. Count one is entitled breaking and entering a vehicle to steal property between $200 and $1,000. It says that you did enter or break into a Chevy Equinox, a motor vehicle, to steal or unlawfully remove property therefrom of a value of $200 or more, but less than $1,000, contrary to Michigan compiled law. That is a misdemeanor offense. It has a maximum penalty of 1 year and or $2,000 fine, or 3 times the value of the property stolen, whichever is greater. Do you understand the name of count one?
It's a misdemeanor count, correct?
That's correct. Do you understand the name of it to be breaking and entering a vehicle to steal property between $200 and $1,000?
Okay.
I just need to know if you understand that, sir. Not asking if you agree with it.
Yes, I understand.
All right. And you understand the misdemeanor maximum penalty is 1 year and or $2,000 and up to 3 times the value of the property, whichever is greater?
Yep.
All right. Count two reads as follows. It says that on the same date, time, and place that you did commit the offense of breaking and entering a vehicle to steal property less than $200. And that says that you did enter or break into.
Welcome back to the channel, and buckle up because today's courtroom session doesn't just escalate, it detonates. We're stepping into the arraignment of Jonathan James Winter, a defendant whose criminal past, present charges, courtroom behavior, and timing of new allegations collide into one of the most jaw-dropping sequences you'll ever witness. From misdemeanors that sound simple at first, breaking into 2 separate vehicles, to an unexpected avalanche of new charges, a parole hold, a prior home invasion history, and a judge who keeps complete command of the room. This case is a full-blown roller coaster.
You have the right to plead guilty, not guilty, or no contest. You have the right to an attorney to represent you, and you have the right to have a trial by a judge or by a jury. Mr. Brown is here to assist us with the attorney, and we'll talk about that in just a minute. If you wish to have a trial in the future, you also have the following trial rights: to see, hear, and question all the witnesses against you, to present witnesses and evidence for your defense, and to get an order from the court called a subpoena to require those witnesses to appear and testify. At trial, you could also testify, or you could choose to remain silent. And if you chose to remain silent, that silence could not be used against you. You'd also have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof be on the prosecutor at all times. Finally, you'd also have the right to appeal automatically any error that happened at trial. However, if you enter a plea in the future, you may be limited to asking the court for permission to appeal. Do you understand all of those trial rights?
Yes.
Do you have any questions about any of those trial rights?
No.
All right. Mr. Brown, have you had a chance to speak to Mr. Winter about his right to an attorney?
Yes, Your Honor. He would qualify, and that information has been sent to Mr. Keel's office.
Thank you. Mr. Winter, are you asking for court-appointed counsel?
Yes.
All right. I will approve that request. That request has been submitted to that approval will be submitted to Mr. Gilo, who's the supervisor of the court-appointed attorneys. He will decide which specific attorney will be assigned to you for your case. In the meantime, I'm going to enter a not guilty plea on your behalf in order to protect your rights until you have a chance to speak with that lawyer. I'm also going to set a pretrial conference quickly so that your lawyer can speak with the prosecutor and see if they can resolve the case quickly as well. Do you have any questions about those procedures, sir?
No, I just need to be able to talk to my attorney because there is extenuating circumstances.
Well, we'll get into that later. You don't want to talk about anything right now, Mr. Winter.
Yep, and that's why I've set a quick pretrial conference.
Right here is where the judge starts laying out the foundation. And even though this seems routine, seasoned courtroom watchers can already see the tension building. Notice how the judge breaks everything down clearly. the charge, the name, the legal definition, the maximum penalty. This isn't just formality. Judges do this because defendants often claim, "I didn't know what I was charged," later in the process. What's interesting is how Jonathan responds. Not combative, not confused, just very clipped answers. Yes, yep. Those short replies are common when defendants are anxious, unsure, or trying not to say something that may hurt them later. And with his criminal history, he likely knows exactly how strict these proceedings can become.
Within motor vehicles that were part of a string of essentially vehicle burglaries. And on top of that, his criminal history is quite extensive. It is listed in that recommendation form. He's out on parole for a home invasion second degree. So he's got a history of stealing other people's property. That wasn't even his first home invasion. He had another one back in 2008. So like I said, he's on parole for that. He does have a parole hold. I confirmed that with Agent Doug DeLeo with the Department of Corrections. So there is an administrative warrant that's holding him. So regardless of what the court sets the bond amount at, he's not going anywhere, essentially. So in addition to the amount requested, we are seeking that there be the standard conditions of bond, along with no drugs or alcohol, no illicit controlled substances, and then to not have any contact with Timony Bonifant or Mallory Bonifant. They are the two vehicle owners that are in this case, and then also not to return to the property of 19 Grove Avenue here in Gaylord. That's the property where the theft occurred.
All right, Mr. Brown.
Thank you, Your Honor. Mr. Winter is a lifelong resident of this county. He has ties to this community. I don't think he's going to go anywhere. Failure to appear is not really going to be an issue. It is my understanding he did, or possibly was arraigned yesterday on an FOC warrant. So I don't know if there's a significant bond in that matter as well. But as Mr. Fortier mentioned, he is on a parole hold. So bond is really not a huge issue, as he's not going to be able to bond out no matter what it is set at. But I would ask the court just to consider the charges. These are misdemeanor charges. Also, he did mention to me that he does.
This section is crucial because the judge is giving Jonathan the full breakdown of his trial rights. And you can tell this isn't just a checklist. Judges do this with extra precision when dealing with defendants who may have prior convictions or may struggle to navigate complicated legal situations. What stands out is how quickly Jonathan answers each question. It's almost too quick, like he's rushing to get through it. Rapid yes and no answers can be a sign of someone wanting to fast forward through uncomfortable information. But skipping mentally doesn't erase the importance of these rights. Notice also that the judge reminds him multiple times. This is a court creating a record proving that he was fully informed, which eliminates future claims of confusion.
Consider it at that point. I would confirm, because Mr. Brown brought it up, there was a friend of the court hearing, I believe either yesterday or the day before. My memory is that there was a bond set in the amount of $4,900 that he could be released upon payment of that. I do not know whether that has occurred yet or not. So I
have not been able to do that, Your Honor. I'm not going to be able to do that.
All right. I appreciate that, Mr. Winter. Thank you. All right. In setting a bond, I am required to look at whether or not the person will appear as required, and then if there's any danger to the community. The prosecutor brings up history, and which is quite extensive, including resisting and obstructing convictions twice in 2004, larceny in a building in 2004, home invasion in third in 2008, prisoner in possession of weapons in 2013, and then a second home invasion, this time a home invasion second in 2019. Also, what the prosecutor alleges is a string of vehicle burglaries, of which this may have been a part. So for those reasons, I would need to believe that Mr. Winter might be a danger to the community. However, these are simply misdemeanor matters, and I do believe that $5,000 cash and surety is a little high on that end, given the fact that he has a parole hold and also an FOC warrant with extensive, a relatively large dollar amount on it. It's unlikely he's going to be able to post bond, so therefore I'm not going to set the bond in this matter quite so high. I will set it at, because of his prior histories, I'm not going to give him a 10% bond, so I will set it simply at.
This is one of the most fascinating behavioral moments in the entire hearing. We watched Jonathan teeter between self-control and impulsive commentary. It's almost like watching two versions of him switch places mid-sentence. He knows he shouldn't speak. He knows the judge warned him. His attorney is right there. And yet, he starts slipping into explanations that he clearly hasn't thought through. This pattern is extremely common in defendants with anxiety, confusion, or even untreated mental health issues. He tries to explain everything at once. His thoughts collide, his words multiply, and logic takes a backseat. You can literally see his mind buffering in real time, as the narrator-style description in the script perfectly captures.
In the city of Gaylord, Otsego County, that you did commit the following two offenses. Count one is named breaking and entering a building with intent. It reads that you did break and enter a storage shed located at 619 West Mitchell Street with the intent to commit the crime of larceny therein, contrary to the Michigan compiled laws. That is a felony offense. It has a maximum penalty of 10 years. You understand the name of that offense?
No.
What don't you understand about it?
What's the date of that offense?
The name of that offense.
Oh, I'm sorry, Your Honor. Yes, I understand.
All right. Do you understand the maximum penalty of that offense?
Yeah.
All right. Count two alleges stolen property, receiving and concealing over $200 but less than $1,000. It reads as follows. It says that on that same date, time, and place, July 7th of 2025, in the city of Gaylord, Otsego County, that you did commit the offense of receiving and concealing stolen property over $200 but less than $1,000 by buying, receiving, possessing, concealing, or aiding in the concealing of an e-bike, stolen, embezzled, or converted property, knowing that it was, or having reason to know that it was the property was stolen, embezzled, or converted, and the value was between $200 and $1,000. That is a misdemeanor offense. It has a maximum penalty of 1 year and or $2,000 or 3 times the value of the property, whichever is greater. You understand the name of count two?
Yes.
You understand the maximum possible penalty of count two?
The prosecutor comes in hard here, and strategically so. Even though today's charges are misdemeanors, he immediately anchors the court's attention on the bigger picture, the defendant's extensive criminal past. He lists home invasions, larceny, resisting and obstructing, and prior burglaries, painting a clear pattern of behavior. This isn't accidental. In bond hearings, prosecutors know that judges consider danger to the community and likelihood of reoffending. So when a defendant is already on parole, already facing new accusations, and potentially connected to a string of vehicle burglaries, the prosecutor uses that history to justify a higher bond and stricter conditions.
Subsequent offense by saying that appearing that on June 14th of 2012, you were previously convicted of attempting to commit, receiving and concealing stolen property, $200 or more but less than $1,000 in the 87A District Court, and therefore this is alleged to be a second or subsequent offense. And because it is a second or subsequent offense, it is now a felony offense, which has a maximum penalty of 5 years and or a $10,000 fine or 3 times the value of the property, whichever is greater. Do you understand now that count two has been raised to a felony level offense?
Yes.
All right. Now, as to both count one, which is a 10-year felony, and count two, which is now has a subsequent offense notice, which raises it to a 5-year felony, there is also a habitual offender notice, habitual offender fourth offense notice, which also has the impact of raising the penalty. So I want you to listen carefully to this as well. It says that you are previously convicted of 3 or more felonies or attempts to commit felonies. In that on or about July 29th of 2019, you were convicted of the offense of home invasion second degree in violation of the Michigan compiled laws in the 46th Circuit Court for Otsego County in the state of Michigan. On or about April 4th of 2017, you were convicted of the offense of prisoner possessing contraband in violation of the Michigan compiled laws in the 46th Circuit Court for Otsego County in the state of Michigan. And on or about May 7th of 2013, you were convicted of the offense of prisoner possessing weapons in violation of the Michigan compiled laws in the 46th Circuit Court for the County of Otsego in the state of Michigan. Now, because these two, count one and count two, both have a penalty of 5 years or more, the fourth habitual offender notice makes each of those a potential life felony offense. You understand the new maximum penalty on both count one and count two is now life imprisonment?
This defense argument takes a very different tone, and it's smart. Instead of challenging the prosecutor point by point, which would be uphill given Jonathan's record, the defense shifts the focus to practicality. By framing bond as irrelevant, the defense tries to defuse the prosecutor's push for $5,000 and redirect the judge toward fairness and proportionality. It's not about pretending the charges are small. It's about emphasizing that bond shouldn't punish someone when release isn't even an option. Another important moment is the mention of Jonathan's mental health and medications. Defense attorneys often raise this to show vulnerability and ensure the jail provides proper care. It also signals that the client may not be fully stable, which can subtly explain some of his earlier courtroom behavior.
That silence could not be used against you. You would also have at trial the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden remain with the prosecutor at all times. Finally, at trial, you'd have the right to automatically appeal any error. However, if in the future you enter a plea, you'd be limited to asking the court for permission to appeal, and that might not be granted. You understand all of those rights that I've just given you?
Yes.
You have any questions about any of those rights?
That's why I talked to my attorney, Your Honor.
All right, that's a good idea. Mr. Brown, have you had an opportunity to discuss counsel with Mr. Winter?
I have, Your Honor. He will qualify. That information has been sent to Mr. Gilo's office. I currently represent him on another case. It is more than likely I'm going to be appointed to this one as well.
All right. So, Mr. Winter, what I'm going to do is I'm going to appoint court-appointed counsel for you, or approve court-appointed counsel for you. That information is going to be sent to the administrator who deals with court-appointed attorneys, who will appoint a specific attorney for you. That may be Mr. Brown because you already have a relationship with him. But in the meantime, until you have a chance to speak with that lawyer, I'm going to enter a not guilty plea on your behalf in order to preserve your rights. I'm also going to set a couple of quick court hearings to help preserve your rights. The first will be set within 7 days. That's called a probable cause conference. That's a chance for the prosecutor and the defense attorney to discuss the case and see if there's a way to resolve it quickly. I'm also going to set a preliminary examination within the next 21 days. That's a hearing in district court before me as the judge to find out if there's a small amount of evidence called probable cause to believe that you've committed the crimes that you've been charged with. It is not a determination of guilt or innocence.
Just when you think this hearing is winding down, the real shock drops. A second arraignment with upgraded and significantly more severe charges. The shift from misdemeanor vehicle break-ins to felony breaking and entering a building, plus receiving and concealing stolen property, completely changes Jonathan's legal landscape. That means his past convictions don't just sit in the background. They actively increase the punishment he now faces. A habitual offender for offense enhancement can turn even lower-level felonies into serious, high-penalty cases. This is where everything tightens. Freedom is no longer...
I'm going to ask each of the lawyers what their thoughts are on bond, and then I'm also going to give you an opportunity to tell me what you want me to know about bond as well. Mr. Fortier, your thoughts as to bond.
Your Honor, Mr. Winter has a terrible criminal history. He has 6 or 7 prior felony convictions, several misdemeanors. He does have a administrative warrant that's been placed on him by Agent Doug DeLeo with the Department of Corrections. So he's not going anywhere on the parole violation. So I would just ask the court to just set a bond amount, knowing that he's not going to go anywhere. And then in the event that somehow he is able to bond out, just having the standard conditions of bond put in place, and that there be no consumption of any alcohol or illicit controlled substances, no bars, random testing, to report via community corrections, and that he not have contact with the victim in the case, which is, his name is Jason Vanderlaan. and not to return to the address listed in count 1.
What a case. What started as a simple misdemeanor arraignment quickly spiraled into a deeper look at an extensive criminal history, a parole hold, a series of prior convictions, a prosecutor painting a concerning pattern, and a defense trying to maintain stability and fairness. The judge weighed everything carefully, lowered bond appropriately, and ensured the defendant's rights remained intact. But the story didn't end there. The second arraignment shifted this from routine to major: felony breaking and entering, stolen property charges, and habitual offender enhancements that dramatically elevate the stakes. Jonathan's future now hinges on far more serious allegations than the opening minute suggested.